All rise. The Honorable Justice of the hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now.
Thank you. Please be seated. Good morning. Welcome to this morning's docket. We're glad to have all of you with us today. And that includes those who might be watching us on our YouTube channel. I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the morning. It's 9 o'clock docket.
Thank you, Honor. The first case on the 9 a.m. docket for Tuesday, December 13th, 2022 is appeal number 123185, State of Kansas versus Corey Wayne Bentley, Sedgwick County, briefs both sides.
Your Honor, my name is Randall Hodgkinson. I'm here today on behalf of Corey Bentley, and I'm ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Second case is appeal number 123783, State of Kansas versus Marnez L. Smith, Sedgwick County, briefs both sides.
May it please the court, James Ladd of the Appellate Defender's Office representing Marnez Smith, ready for argument.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state, present and ready for argument.
Your Honor, that concludes the 9 a.m. docket.
Thank you, Mr. Shima. Before I call the first case, I would like to explain that Justice Wall missed yesterday's oral arguments and as also today's because he is under the weather. Fortunately, he is feeling up to listening to your oral arguments as he did yesterday and plans to do that again today. So he will continue to participate in the decision making on. I also want to explain to those who are visiting the court or who are perhaps watching us on the YouTube, visiting in that way, just a little bit about the fact that the court has read the cases, information, the briefs, parts of the record, and other materials before coming into court today. So we are familiar with the facts of the case and the legal arguments, and we are here today to engage in some questions and to hear more from the attorneys that will help us better understand their arguments. You will at times see us on our computers, checking our notes, looking at the record, looking at case law. We're not doing that because we are not listening, but because we are trying to better understand what we are hearing as we listen. So all of this helps us with our understanding and the processing of the case and the issues and in making our decisions. So we just wanted to explain that just a little bit for those of you who might not be familiar. With that, I will call case number 123185, State v. Bentley.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Corey Bentley. I request 5 minutes for rebuttal.
5 minutes is granted.
Your Honor, just a reminder that this is a possession with intent to distribute prosecution out of Sedgwick County. My client in this case was arrested by officers after a chase, sort of, and was found to have baggies on his person that contained methamphetamine. One was about 7 grams and one was 20 grams, I think. And so there are a lot of moving parts in this case. And so I have an idea where I want to start, but I know the court will drive the bus wherever it was, and we'll be happy to go there. And so, but I'm wanting to start today with issue 4, which has to do with the interpretation of KSA 215705 governing possession with intent to distribute. And an issue that's coming up and I guess makes sense is that it's sort of coming up as that statute and the scheme that we have for sentencing persons who are convicted of possession with intent to distribute has changed over the past. Once upon a time, the amount had no direct relevance, but now under 5705, the amount that a person possesses with intent to distribute is an element of the crime and has to do with the severity level of the offense. So just to make clear, the issue that we're talking about here is the statute says if you have more than 3.5 grams the statute says it's illegal to distribute or possess with intent to distribute different things like methamphetamine. And the statute says if the quantity of the material is more than 3.5 grams or less than 100, then it's a severity level 2 drug offense. And so the question in this case is, does that quantity of the material refer to quantity of any material possessed or quantity of material possessed with intent to distribute? So the hypothetical I would give is, let's say I have 4 grams of methamphetamine and I can conclusively show I intended to use 2 grams of this and I intended to distribute 2 grams of this, a high school, law school exam type hypothetical. The question in this case is, do I possess 4 grams with intent to distribute, or do I possess 2 grams with intent to distribute? And that would make a big difference in our sentencing scheme. And so that's the question that we're here today.
Would an instruction on a lesser included in terms of, it's framed as a different weight of methamphetamine is a different severity level. And I think your client was in the level 2 based on the 20 grams that he possessed. Is that right?
If the jury believes he intended to possess all of it with intent to distribute, or that's really the question here.
You're kind of the all of it is what you're talking about, as opposed to distribute some of it. And your point is that there needs to be something that would indicate he'd intended to distribute all of it. I just want to understand how you're framing it.
My argument is that this is a reasonable argument, that this hypothetical that I've sort of put out is a reasonable argument, that I might possess 2 grams with intent to use it or for some other purpose, and 2 grams with intent to distribute. And if so, the jury would be called to make that decision whether the state had proved beyond a reasonable doubt that I possessed more than 3.5 grams with intent to distribute.
I reviewed the was that argued or was that presented to the jury that your position? What I understand was that it was kind of, the defense was, no, this was for personal use. That was pretty much all of it was for personal use.
So the instructions in the case, the pattern instructions, the current PIC instructions reflect the idea, the argument that I'm making, that the jury has to find beyond a reasonable doubt that more than, for example, 3.5 grams were possessed with intent to distribute. That's the current PIC instruction. And that, I think, was given in this case. The way this was raised in this case is my argument that a lesser should have been given. That there was evidence in this case. I'm not saying that there wasn't, some evidence that would support the conviction, but I was arguing that there's also some evidence that would support a lesser in this case. But that only works assuming, well, maybe it works even if I'm wrong, but particularly as the Court of Appeals decided this case, the Court of Appeals said that's irrelevant. In fact, under the Court of Appeals rationale in this case, I could not make the argument in the hypothetical. It would not be an ethical argument for me to make to a jury because the Court of Appeals said it's irrelevant. All that matters is you possess this amount.
If we agree with you that lesser should have been given, and maybe just under our new rubric here, our rubric that it's factually appropriate if there's sufficient evidence to support the finding of the lesser, what would we do with that based on your argument? The lesser should have been given. It's clear error standard at this point. Is it clear error?
Then, you would either have to do the clear error analysis or, the Court of Appeals said we're not even finding error here.
I understand.
So another option, of course, is to remand it, I think, to the Court of Appeals to make that determination in the first case. But yes, So if I get to that part, but the statute, I think the statute's really clear that 5705 only deals with possession with intent to distribute. So I think the plain meaning, we have another statute that deals with possession. It's 5704. And the legislature could make that based on amount, but they haven't. So I respectfully suggest that the Court of Appeals decision is wrong on the law there. Now, if you get to the clear error in this case, then you have to look at all the facts of the case and decide, could a reasonable jury, are you firmly convinced that but for this instructional error, the outcome would have been different? Is there a real possibility that the outcome would have been different? And we argue in the brief that yes, I mean, particularly given what my client said, my client testified that he was planning to use a lot of this. And the state's primary argument that he was going to distribute this was his own statements that he was going to break off some of this to pay for staying in hotels or something like that. And so is there any particular evidence that would necessarily cause a juror, all the jurors to form, to be convinced beyond a reasonable doubt that he was going to distribute more than 3.5 grams of that? And that's our argument, that no, particularly given his testimony that he was using, and that he used a lot of methamphetamine, that it was that one or more jurors could easily have formed a reasonable doubt on that fact. And it's not an imaginary hypothetical, that's based on the evidence in this case. So that would be our argument for clear error.
I presume you, at least it seems consistent to me that your argument would require not one lesser, but actually two lesser. It's two separate lesser included instructions, one based on subsection B and one based on subsection A.
For the different levels of.
For the different levels.
For the different levels. I think it was certainly under this court's precedent would be factually appropriate. And given the testimony, yes, although we don't have to have all of those in necessarily to get a new trial in this case. I mean, I think this court could surgically decide one's clear and one's not.
In a hypothetical case, in which the district court actually gave a lesser based on B, but failed to give a lesser based on A, I presume you'd still be here making the same argument. Like, hey, we should have got this a second lesser also.
All the lessers are legally and factually appropriate. And I think that's correct under this court's precedent.
My follow-up is based on your position, any drug severity level 1 felony that's charged under subsection D, 100 grams or more, just automatically gets the 3 lessers in every charged case, correct?
At least if the defendant requests them or doesn't.
Well, it would be error not to give them.
Yeah, I mean, if the defendant objected to giving lessers, I suppose that's a different story. But in the absence of the defendant's objection to giving them, then yes, we think that it's factually, under this court's precedent, it's legally and factually appropriate. Whether it's reversible is another question, I understand.
I want to move you over to the jury waiver question on the stipulation. And I need to go down a couple of layers into that argument and kind of skip over some stuff. I want to get all the way to whether harmlessness would apply to this particular waiver. And so as I'm looking at the differences between cases on structural error, versus harmless error kind of situation, part of them talk about reason you go ahead with structural is you don't want to speculate too much. That's the premise. What I'm wrestling with is whether the speculation we would have to do with this particular stipulation is any different than when we get to clear error on a lesser included offense, when we're trying to decide whether a jury would have arrived at a different outcome. You see what I'm getting at? Seems to me figuring out whether the jury would have done something different, but for error in the lesser included offense area is sort of the same kind of analysis. But I wondered what you thought of that.
Yeah. So certainly this court has never applied harmless error to this type of error before. And I mean, the idea, and when we look at Irving and Fry and all the cases where this court has ever said there's a failure to have a proper jury trial waiver on the record, this court has never said, but would the outcome have been the same anyway? And I would suggest to you that you don't do that analysis because it wouldn't make sense. That's not the point. The point isn't that I think necessarily a jury would have come to a different conclusion. The point of the right to a jury trial is I know that a different fact finder would have made the decision. That's a different outcome.
Getting back to Justice Biles' point, assume we get to the harmless analysis as opposed to structural error. And I think part of the rationale would be neater in those lines of cases look at an elemental kind of failure versus the entire framework of the jury trial waiver and what that encompasses. But let's say we get there. What is and just to kind of highlight, what is the lens that we look at harmlessness here? You know, in my mind, can we look at the question of whether Mr. Bentley would have entered the stipulation anyway? And it just seems to me there's evidence to support the fact that he would have. The whole point of entering the stipulation is to keep out prior criminal history, all of that type of evidence that leads to the prejudice that can result from letting in the details of a prior. And how far can we go to look at that? Because in my mind, there is evidence to support that he would have entered it anyway. And so is that part of what we can look at?
Your Honor, I see my time's out. Can I respond? Justice Rosen, so I feel like
I hope I made my, yeah, that's fine.
I think there's a lot of layers to your question. And so, I mean, first of all, I would argue, again, really clearly, I don't believe harmless error applies to this.
I know you do.
And because I do think it is really along the lines of a structural error that the right to a jury trial is so fundamental that it's not that we think a jury would have come up with a different decision. It's I have a right to have a jury make that decision regardless of the outcome. But be that as it may, it's very difficult to answer your question because we don't have any sort of cases that talk about where there's, I mean, because this court has always steadfastly said if there's a failure to have a proper jury trial waiver on the record, the right remedy is send it back for a jury, that conviction was in violation of the right to a jury trial, and therefore it needs to go back. The only remedy is sort of to fix that. Is there, as Judge Garner sort of suggests in this case, is there some sort of an exception in a case like this? And I understand what you're saying, Your Honor, that this is a very typical stipulation. There's a lot of strategic reasons for this stipulation.
By defendants. I mean, that's the whole point is
Sure.
I want to keep this evidence out.
So it's perfectly reasonable. Nobody's saying, you know, that this is to be discouraged or anyway. It's just to say, because of the fundamental nature of the right to a jury trial, as the court said in Johnson, we need to make sure on the record that this is your decision, because clients make bad decisions all the time, even where we would say this was really the thing you should do. If the client said, that's not what I want to do, though, I want to preserve all of my jury trial rights on every essential element, that's their prerogative. And the only way to ensure that is to make sure that's on the record. I don't know how it's going to be, you know, litigated. I was pondering a little bit, Your Honor, as I was sort of going over these and thinking about this court has really articulated, for example, the purpose of the contemporaneous objection rule. And the idea that you've articulated is, look, we want to get these things taken care of at the trial court. We don't want these things coming up later. And the same line, it's really the same values here that we're arguing for when we're saying we need to make these records on these kind of fundamental decisions at the time, not later. And in the absence of that, I don't know how you get to sort of even a reasonable harmless error approach to this case. How do I mean, Justice Rose, you talked about two different things, because is the outcome, would the client have waived it, or is the outcome he would have been convicted of it? What even outcome are you talking about for your harmless error analysis? Because those are different when we talk about like plea withdrawal cases. What's the outcome that you're talking about?
Many other states and the federal courts that take this view under Rule 11 do apply a narrower view, and looking at it, would the defendant have made the waiver? Would the defendant have entered a plea? Those sorts of things. And there are obvious situations, and I think the record may support some of it here, where the court can conclude that because the defendant would not have wanted prior convictions to come in or other evidence, that the defendant would have stipulated there. So why is that view that those courts have taken of using that narrower lens not a possibility, or why would that be bad policy to do that?
Yeah, I mean, it would require, I think, it would require some individualized finding. I mean, the idea that, I mean, if you took the broader view, and I don't, if some of these courts take, I mean, certainly some of these other courts take a very low view of the right to jury trial. I get that. I'm hoping this court doesn't go down that road. And I don't think based on our constitution, you should. But you still would have to have an individualized decision in that regard. Because as you've already noted, and I think correctly, I'm not arguing that it's often, maybe almost all the time, the right decision to stipulate to a prior in this kind of situation. And if you adopt that, then this is never going to be reversible error. And it won't make any difference what an individual, you would need some evidence that the individual in this case was informed of it and made that decision to their attorney. And there's certainly no evidence of that in this case,
Well,
of
isn't
an
there,
individualized decision.
there's a suggestion, at least at the ineffective assistance of counsel hearing, that, yeah, the reason we entered the stipulation was kind of keep out this propensity concerns that we're talking about. And that was the purpose. Isn't that, there's two different portions of that discuss that.
That's what the defense,
Isn't that an indication that there's some evidence here that he would have entered into it?
that the defense attorney wanted to enter into it. And that's a reasonable decision. That's not an individualized decision on the part of my client,
And I think
after
so.
being clearly informed of his right.
I'd like to take a little different tack on that. What if the stipulation is for an entire element, but possibly not an entire element, such as on the venue question, for example, they stipulate to the around the globe, the horizontal point, but they agree to the north-south point, that this is where it is located, but they don't agree to the point. And then they agree that there is some kind of an identifying characteristic to the landscape, latitude. They agree to the latitude, but not the longitude of where the event occurred. They agree that there is an identifying post within 50 feet of where the event occurred, but they don't stipulate to venue. Are those stipulations okay? Are they merely evidence that don't require a jury admonition?
So if I'm understanding your question correctly, you're asking sort of like if there are some predicate facts that are the parties can stipulate to all sorts of facts,
And you don't need a
and
jury
predicate
waiver.
facts that might lead to a conclusion of the element, is that covered? And I think Johnson, I mean, I'm going to go back to Johnson all the time because that's this court's pronouncement. I think no, not necessarily. You have to find something that you would say is essentially stipulating to the element, taking the element out of the jury's hands. Now, there might be different ways that happens, but I'm not sure just stipulating to a predicate fact that doesn't necessarily lead to a conclusion would do that.
But
If it did, then I would say yes. If it functionally does, then yeah, I would still be here arguing that.
So who keeps track of that then? Must the court keep track of whether all of the predicate facts gathered together add to an element such that now I have to give a jury waiver?
Sure. I mean, I'm not troubled by that if that would be the result. I mean, I don't think this is a situation that comes up a lot. And to the extent that this court would make it clear, I mean, there's an easy solution for a district judge in any case if they're like, boy, I don't know if this is, an elemental stipulation now or not. There's an easy solution for the district judge, right?
Right. Every time you take a stipulation, you give a jury trial waiver.
Yeah.
No matter what it is or how extensive it is, as opposed to the way any other evidence comes into the case, right?
So if there's anything that sort of even smells like an elemental stipulation, I think the judge has, I can solve that problem. And by the way, the state nor Judge Gardner in her concurring opinion have shown any reason like, why would this rule, why is Johnson bad policy? How is this impeding, is it impeding defendants from stipulating to element? We know that they're not. I'm getting cases all the time now where this court is following, where district courts are following this court's judgment in Johnson. It's not hard.
Let me ask a follow-up that occurs to me. What if the defendant testifies and on cross-examination, the state asks, do you agree that you possess this weapon or whatever the element is? And the defendant says, yeah, I'm not contesting that part of the case. In front of the jury. I mean, the
Sure.
defendant's in the witness box.
Sure.
Does that require a jury trial waiver? And if no, because it strikes me the answer probably is no. Is there any difference?
Yeah. I think the answer, I'm fairly confident the answer is no, because the jury doesn't have to believe the defendant. Right? When you stipulate the evidence, we tell a jury, you're not even considering this point any longer.
So that's the primary difference.
So that's a primary difference.
Is that the jury is getting an instruction from the court that this is off the table. As opposed
You shall
to
consider this as true.
just sort of overwhelming evidence, which still could be disregarded. Is that the distinction you would rely on?
Yes. I mean, I want to be really careful. I want to be really precise with you, Your Honor, that there may be other issues.
Right.
Regarding Fifth Amendment and things like that get tied in there. But for the purpose of the discussion today, yeah, I think that would be the distinction. Thank you, Your Honor.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. And just briefly, I want to thank the court and the clerk's office and opposing counsel for accommodating my schedule this week. It was much appreciated. I'd like to begin with the stipulation jury trial waiver issue, if that's all right with the court. And I want to begin by explaining why, in the state's view, a stipulation of this kind is not akin to a jury trial waiver.
Okay, can you start with Mr. Hodgson's last point? What argument have you made, or even the Court of Appeals decision seem to not address, is that what's the harm in this? Have you addressed why is this a problem? I mean, in order for us to overturn precedent, don't you have to state a reason that some benefit would come from this? And I don't see where you've said that.
Well, I think to the extent, I think the defendant obviously was the one who raised this issue, arguing that this was akin to a jury trial waiver. And I think that I don't know that the state actually would need to show a harm. We would just need to show that this is not akin to a jury trial waiver, unless the defendant can.
Well, don't you have to adhere to principles of stare decisis?
Well, I would argue that stare decisis for decades before Johnson was that this was not a jury trial waiver.
Well, but that's not how stare decisis works. I mean, do you disagree that Johnson controls this issue?
I do not. No, I agree. I mean,
so if Johnson controls this issue, then for the state to prevail, it has to articulate a reason for this court to overrule Johnson. And that would require stepping through the stare decisis principles, would it not?
Well, I think I did that.
Well, I think that's what Justice Rosen is asking. And it sounded to me like you said, no, we don't have to do that.
What I said was we don't have to show a specific harm to having a defendant do this. But that's only one way to show why the decision was wrong. And I set forth numerous bases for that in my petition for review, as did Judge Gardner in her concurring opinion.
I think that our stare decisis doctrines suggest that the burden on the party seeking to change precedent has to show more than just that it was wrong.
Well, with the court's permission, I could think of two reasons off the top of my head why this is what the harm is, to the extent that's the specific question before me. One is that I think that requiring a jury trial waiver every time a defendant stipulates to an element or a part of an element or simply doesn't contest an element is that encroaches on trial strategy. Decisions that are made routinely between a defendant and his attorney. Just as one of the other issues in this case, talking about a guilt-based defense. And this court's case law has held for years that while obviously that is a decision that belongs to the defendant, that it's not something that requires an on-the-record discussion with the court. And a court of appeals opinion that I've cited in that issue indicates that one of the reasons why it would be unwise to do so is because it would potentially encroach on defense strategy. And so I think in a situation like this, where as we've all acknowledged, or as this court's acknowledged in questioning here, stipulations are almost universally to the defendant's benefit, and they're almost always done at their urging. And so when you have something like that, that a defense attorney and the client have no doubt discussed at great length and decided that, yes, we want to keep out the nasty details of your prior convictions. We'll just stipulate to the fact that you have those convictions. I think that if you, every time a defendant does that, if you then turn this into something requiring a waiver on the record, that possibly does affect the defense strategy. And
How does it?
It might cause, just like when the court is to, this court has said, we don't want the district court, we would prefer the district court not to, on the record, talk with the defendant about the right, whether he's going to testify, because we're afraid that just by the very nature of that discussion, it might sway the defendant one way or another.
Doesn't that suggest that Johnson was right on the merits? In other words, you're arguing to us that the good that would happen or the harm that happens from Johnson is we're afraid that if we actually tell defendants they're waiving their jury trial right, a percentage of those defendants will be like, whoa, I'm not doing that. And isn't that significant? Doesn't that significantly suggest that Johnson's right?
No, I think it just, my point simply being that I think the very fact that it would cause a defendant to second guess or even hesitate on a strategic decision that he and his attorney have already made, that in itself is the harm, regardless of whether he ultimately then changes his mind or not. It's just the fact that.
How is that a harm? I mean, the right to a jury, you're suggesting that the strategic objectives of defense counsel are a higher priority than the defendant's constitutional rights.
Well, I'm not suggesting that, because my position is that this is in no way, shape, or form a jury trial waiver. And
Isn't it true that most evidence that is a subject of a stipulation could come in a different way? You could have testimony, say essentially what is in the stipulation, and the agreement is simply not to object. Couldn't that happen?
I suppose there's no limit on how something could be brought in. So I guess your question being, in this
Isn't-
situation, they could just ask the defendant, were you convicted of a prior firearm offense?
Well, isn't it true that the stipulation is just simply another form of evidence that is submitted in a trial in a particular way?
Yes, I think that some of the case law indicates that it's not exactly to be considered evidence, because it essentially is an agreement by the parties. So it's
But
An
it can
agreement
be-
by the parties not to submit the element to the jury. That's what it is.
except, and I think this is very significant in this case, because some of the, even I believe in the federal case law that this court relied on in Johnson, specifically Mason was the primary circuit court case that this court relied on. But in Mason, the element that was stipulated to was in fact taken away from the jury. It was not instructed upon. The jury had no ability to decide on that element. But in this case, even the element that was stipulated to was included in the jury instruction. The jury still had to make a determination. And just as a jury can always choose to ignore all of the weight of the evidence in a given case, we all know that happens. There are trials where it happens and everybody is left wondering, how did the jury possibly come to that conclusion?
So how did the jury get the stipulation in this case?
It was read into, the stipulation was read during trial, and I think it was also,
Like by a witness or?
counsel might remember the record. I don't specifically remember if it was read by the judge or who specifically read it, but I do
And-
believe it was read.
Did the jury get an instruction from the court on the stipulation?
I believe there also was something in written form.
Well, yes,
given.
there was. And what it said was you may consider the elements as proven by the agreement. I mean, you're
May being the
you're
key word there.
suggesting that a jury can ignore an instruction that says you can consider the elements as proven as it gives to this.
Well, the word may, I think conveys discretion there. I think that it's certainly not a directed verdict. It's certainly not saying you have no ability to make an independent decision on this. And the very fact that it.
Can the state then come in and offer evidence in addition to the stipulation? Because the jury might ignore that instruction, Your Honor. I want to offer some more evidence here about the propensity evidence that comes in with the prior crimes. Why couldn't the state argue that? and
Well, I think
say,
there's-
introduce more. I don't understand how a jury ignores the stipulation.
Well, I think there is case law saying that if a defendant agrees to stipulate, the state is not free to then present other evidence on it. So I think the answer to the question is no. But one thing that came to mind as I was preparing for this argument that I feel is very significant to distinguish this from a jury trial waiver is if a defendant waives his right to a jury trial, he cannot then directly challenge that conviction on appeal. If you have pled something and waived your right to a jury trial, you do not then have the right to appeal that on direct appeal and say, the state failed to prove the elements of this crime that I just pled guilty to. But here in this very appeal, a direct appeal, if he wanted to, he could have challenged the sufficiency of this conviction up to and including this element. We have seen times where in case law, the parties simply draft a stipulation and they're sloppy in doing it, and they fail to properly and fully set forth the elements that the defendant is purporting to stipulate to. And if that happens, if the district attorney's office messes up and drafts an element or drafts a stipulation, and we think that we have sufficiently covered that element, and in reality we haven't, the defendant would absolutely be able to come before this court or the Court of Appeals and say, hey, I realize that I stipulated to element 2 of this offense.
How would they be able to do that if they waived their jury trial right on the element? I mean, that seems to me to be a net positive for the state from the Johnson rule.
I'm saying that if they actually had waived a jury trial, they can't. But in this situation, which I'm arguing is not akin to a jury trial waiver, if it's just a stipulation.
But let's just say the Johnson rule had been followed here and there was a jury trial waiver, and yet the defendant still tried to appeal sufficiency on this issue. You would be at the podium saying, whoa, you waived your jury trial right. You don't get an appeal on this.
If the Johnson universe is what continues to apply, then yes, we will adapt to that case law and we will make the appropriate arguments at that time. But we're here today trying to get you to overturn Johnson and go back to what had been the case law for decades before. And I cited in the petition that this court never addressed White. You know, this court's analysis in Johnson was essentially 2 paragraphs, and it never addressed White, which was a case in which the defendant stipulated, literally the stipulation said that he was agreeing that he was guilty to every element of the offense of first-degree murder. And the argument on appeal was, hey, the district court needed to comply with 223210 and do the full panoply of plea rights and go through that whole process. And this court, the Supreme Court, said no.
Wasn't that done after a jury trial waiver had been effectuated and then a stipulation was entered into?
Yes, I think there was.
So wasn't that's a big distinction. Defendant and White had already waived right to jury trial, and then was further stipulations after that waiver had been entered. That seems to me a big difference.
It's a distinction. I certainly acknowledge that, but I think it doesn't defeat the point that what the Supreme Court said in that case, though, is that holding indicates that Doing that, stipulating to something still is not akin to a guilty plea. There's still a trial here. When all is said and done, if you had walked into the courtroom at any point during this defendant's proceedings, you would see 12 people in a jury box. You would hear them listening to the evidence. And if you had a camera in the jury room, you would see them deliberating to determine whether he was guilty of all.
I agree with you. It is kind of, he's exercising the very right that he's arguing he should have to waive, because he's in jury trial. He's understanding the procedure that's occurring. There is kind of a conundrum there, at least for me, and on that aspect. Could I move you to the harmless error and
Sure.
some of the discussion that we had with Mr. Hodgkinson? What do you think the lens is, and can we look at, and when we're trying to determine if we get there, whether this is harmless error, can we look at whether or not is part of the calculus here that the stipulation would have been entered into regardless of whether there was a waiver or not, that this was, the points I was making, that this was generated from him and counsel, and it's designed to keep out propensity evidence and prior crimes and that kind of prejudicial stuff that can happen with this kind of thing. Can we look at that as part of it?
I think that's perfectly logical to take a common sense view of it and realize that, as your honors pointed out, this is something that benefits the defendant. There's a reason why this is the one area of the law where case law says that, unlike other issues where the state is free to prove its case any way it wants, here, if a defendant offers to stipulate, the state has to, and it's because it benefits the defendant. And so I think taking that common sense approach to it, it very much makes sense to look at it in the lens of, is there any realistic chance here that the defendant wouldn't have wanted to keep this evidence away from the jury, the details, the particulars of his prior offenses? And I think that also, as Justice Lukert pointed out, you look at some of the federal case law, and it also where some of the circuit courts have applied a harmless error type of analysis to this. And I think it applies that very logic. And I think that would be very much appropriate to look into and say, all right, in this situation, even if this was an error, it shouldn't be structural error. It should be considered for the reality of the situation. And I think, very much so. Would he have stipulated? Is there any realistic chance that he would not have stipulated? And as Judge Gardner pointed out in her concurring opinion, you also have a situation here where the element that he stipulated to, the existence of these prior convictions, is something that would have been easily provable by simply admitting a journal entry of a prior conviction. And so it's not like this was the existence of the priors were not the critical elements of this offense. Let's just call it for what it is. And I think Judge Gardner,
It is the particular charge of discharge of a firearm.
I mean, it's clearly it's an important. I mean, it is an element. It's something that has to be proven. But as she points out in her concurring opinion, what this charge really came down to, and what the defendant was challenging, and he did contest, was whether he actually possessed these two firearms on the date of this incident. And so given the fact that that is really, we all know that in many cases and in many charges, there might be four elements, and it really comes down to one element, that both parties agree that elements 1, 2, and 4 are undisputed, and all we're looking at here is element 3. That's where this case lies. And I think that some of the questions to counsel, is there a real difference between that type of situation where a defendant just doesn't contest evidence as opposed to a formal stipulation? And I do appreciate, I understand counsel's point, that you might have a distinction between actually affirmatively telling a jury in an instruction or in an oral pronouncement that you should consider these elements or this element proven, as opposed to if somebody just doesn't contest. But in reality, I think as you think about it from a jury perspective, and some of your honor's questions about, well, how would a jury actually ignore or come to a different conclusion on an element that's stipulated to? I struggle to see a functional difference in a case where a defendant simply doesn't contest an element, or even more to the point, maybe it's not a formal stipulation, but maybe they just flat out argue a guilt-based defense. And you might have a situation where they, from the very outset of the case, the defense attorney, the defendant himself might say, yes, we acknowledge that element one was proven, that a person was killed here. We acknowledge that it happened in Sedgwick County. So even in those situations, while there might be not be a written instruction to the jury telling them that they may presume that's proved, functionally, I don't know how a jury in that situation would come to a different conclusion. So I think that
Well, doesn't the court's statement, you may consider this to be true, doesn't that unduly emphasize certain evidence? I mean, isn't it really just a reliability issue? Somebody agrees to certain facts as opposed to, I don't oppose a certain fact. Doesn't it really just come down to a piece of evidence and how reliable it is?
reliability, maybe strength, I guess you could also say the strength of it is arguably bolstered when you have a court saying that you may consider it. But again, I still don't think that gets us to the point where we can say that it's actually a jury trial waiver. And that's the hurdle that the defense has to show, is that this truly is akin. And I realize that now that we have Johnson on the books, that is the current state of the law. But we're simply asking this court to reanalyze this issue in light of White, in light of the federal case law that we cited in the brief and that in the petition and that Judge Gardner set forth. And I think when you really consider from a practical standpoint, this just is not the same thing as somebody who is actually waiving his right to have a jury of his peers determine whether he's guilty or not. This defendant got that. He had a jury to determine all of the crimes and all of the elements of each of those crimes. And I would arguably have an even, I think my position would be a little tougher if this were like Mason, the federal case law that we cited, where the instruction removed that element from the jury's consideration. There would have been no way, even if the jury wanted to, they wouldn't have had the ability to find the defendant not guilty because of lack of evidence on that particular element. But here it was still before the jury. They still ultimately were the ones who decided each and every element of this offense. And that's why we feel that Johnson was a mistake. And we simply would ask the court to consider this in more depth than in the Johnson opinion, which did overturn. It was the first case. And I know counsel pointed out that there's really no case law explaining how this would be subject to harmlessness as opposed to the case law telling us that jury trial waivers are structural. Well, the reason why there's no case law telling us that is because before Johnson, this had never been found to be akin to a jury trial error or waiver. So there's been no opportunity for this court to address that issue. So for all of those reasons, again, our position is that this is not a jury trial waiver, and we would ask this court to revisit the finding that it was. If this court declines to do so, we would urge the court to adopt the harmless standard that Judge Gardner set forth, again, with consideration to whether the defendant would have nevertheless stipulated, even had the waiver been secured by the district court. And I know I'm well past my time. So I would submit the other issues on the briefing unless this court has questions.
Thank you,
Thank
Mr. Malone.
Your Honor, I just think I had 2 points for clarification. One, and maybe my colleague is misspeaking, I'm not sure, but certainly Judge Gardner is conflating these ideas, and I think my colleague is conflating these ideas a little bit, that I'm not arguing that what happened here is akin to a guilty plea that would require, for example, in federal court Rule 11 colloquies. I'm saying it's a jury trial waiver, like the Johnson court said, it's a jury trial waiver. And this court for 47 years has made it clear that a jury trial waiver requires on the record to make sure that the client knows they have the right to not waive their right to a jury trial, and to make sure that that's what the client wants. But this is not a remarkable, Johnson is just an application that to say, yeah, that means for every element, that's all.
Would you agree that had Johnson been followed and had there been a jury trial waiver, that your client would lose the right to appeal the sufficiency on that element.
No, and that's the other thing. That's, my colleague said, you know, if he had waived his right to a jury trial, he can't appeal. Yeah, it's just a bench trial, right? Let's say it's a complete jury trial waiver. I can still appeal that conviction. Right? A guilty plea is a waiver of any non-jurisdictional defense, but a waiver of jury trial isn't a waiver of all non-jurisdictional
Well,
defense.
how does that work when it's not a bench trial?
So if Johnson had been following this case, I wouldn't be able to argue successfully that it was a jury trial violation. That's true.
Well, what would it be? Who's making the determination?
Making the determination.
Who's making the determination as to whether the state has met its burden of proof on this element?
Oh, the appellate court would. So,
Well, wait,
yeah. No,
this is an interesting
yeah.
sort of wrinkle here. If it's actually if you're waiving the right to a jury trial on this issue, what you're saying is the jury did not decide this issue. And that's been the thrust of your argument, which is, look, you're taking this issue away from the jury. That's why we need a waiver. And that seems to me to be akin to a guilty plea on that element. But the judge isn't making that determination, and the appellate court's not.
No, Your Honor, I still think and confident asserting that even in the light of a jury trial waiver, the state still has to put on sufficient evidence. Now, that stipulation might be, but even this court recently in Valdez, where there was a stipulation to a prior, and this court said, yeah, but that stipulation didn't meet the element of the crime for criminal possession of a firearm. And you reversed that conviction in Valdez, even after a jury trial waiver, a stipulation on that. So the stipulation still has to meet the element.
That strikes me as inconsistent.
Yeah.
Conceptually, doctrinally.
No, it's not inconsistent at all. The way you waive the right to a jury trial, I might waive the right to a jury trial on the whole case. But the state still has to put on sufficient evidence of all the elements of the crime. And I can still raise on appeal in a bench trial.
Right, but
that there's insufficient evidence of one of the elements.
But the problem is there is no bench trial here. Under Johnson, there's no bench trial.
There is on this element. It's effectively, that's what's akin. It's not akin to a guilty plea. It's akin to a waiver of a jury trial, like Johnson said. That's the difference. So we're not arguing in this case. I mean, that's not this argument.
So
but you could, in a proper case, say they stipulated to this, but that's not sufficient evidence.
So what I mean, this is a new argument, or at least it's not a new argument, but it's a new way of characterizing that you're saying essentially the effect of a stipulation is a bifurcated trial where the defendant gets the jury to be the finder of fact on certain elements and the court to be the finder of fact on certain other elements. That's what you're saying. And well, that's what I'm hearing. Is that what you're saying? I guess it's the more fair way for me to ask the question.
Yeah. I think I feel like it's a little bit of a semantic. And in fact, I think like Mason and some of the cases that are cited, I mean, this idea of, well, what do you do if a defendant does validly waive the right to a jury trial, and a stipulation? Do you still give the element to the jury, or like some of the federal courts, do you not even have it listed in the elements anymore? I mean, that's a question about what you do with that.
Well, those seem to me to be really, really important.
Yeah, they're not before. I mean, it's all predicated though on that there's a valid waiver of the right to jury trial in the first place. And then what do you do with that? I'm not sure yet. And we see different examples of this in cases around the state now. So that could be a next decision. Like once you do that, how do you effectuate that?
My guess is that all the district court judges out there don't think that they're sitting as fact finders when you get a stipulation. That's not what's in their mind.
Yeah, and I don't think they are either. I mean, I think the jury gets that, but as described in the cases you cited in Johnson, the jury is instructed to consider this to be true, and we presume juries follow the court's instructions.
If the jury is,
so they're no longer making that decision.
Seems to me to be crucial in deciding this question. If the jury is actually rendering a determination on the element, then the jury trial is not being waived. I mean, that's the state's argument.
But where there's a stipulation, and again, I think there are different forms this could take, but where there's a stipulation and we tell the jury this is proven, and there are different ways you might do that, but where they told, I mean, that my colleague suggested but Mr. Bentley got a jury trial. The jury decided all the elements, except the one, and I understand what you're saying, Your Honor. And even as we're talking about it, I'm like, and yeah, you're right. I think that is interesting. But at the end of the day, I mean, Johnson correctly suggests and holds that did the jury in this case functionally have to find beyond a reasonable doubt based on evidence the element of this offense? And I think the answer is no. And so that's why Johnson is right.
But as Justice Rosen read the instruction, it was, you may find this stipulation meets the element. That effect, I don't remember.
You were to consider it to be true.
You may consider elements as proven by the.
So, you know, your counsel argued, or your opposing counsel argued, the may could suggest to the jury that, yes, you can reject it. So how does that fit with your discussion?
It certainly runs counter to my understanding of how we do stipulate that when we give stipulations to juries. I mean, if that's not true, that juries aren't bound by factual stipulations. I feel like that would be a new ruling from this court, that they are bound by that, regardless of the language that's used in an instruction like this.
So the fact that in this case, it may be different than the general rule, you would say, no, we should disregard the instruction or.
That it's functionally still telling the jury, at least they're considering it in a different way than they would other elements. I'm worried now it's starting to get into a permissive inference of some kind. I don't want to get in that argument too much. Your Honor, can I have 1 minute just to respond to Justice Rosen?
Yes.
I've been pondering your harmless error question a little bit. And so, okay, let's say you are applying a harmless error here. Well, what is it? Well, it must be a constitutional harmless error, right? Because it's a constitutional right.
Right.
And so the state has to prove beyond a reasonable doubt that my client would have done this anyway. And I'm not sure how you do that on a record in general without pretty specific evidence in the record. I mean, I guess I can imagine a situation, Your Honor, where I have something, something from a client where they got in writing, here, you have this right, and I suggest you do this, but you have the right to not do this, and I won't do it if you tell me not to do it. And there's a witness, you know, so maybe there's some world where that's it, but that's certainly not this record. And in fact, as outlined in issue 3 in this case, we see that actually really apparently was some disagreement between counsel and the client with regard to, you know, all these things. And so particularly on this record, I don't know how you would find that beyond a reasonable doubt.
Right. With it.
Thank you, Your Honor.
Thank you to both counsel for your arguments this morning. Court will take this appeal under advisement. I will now call 1-2-3-7-8-3 State v. Smith.
May it please the court, James Latta of the Appellate Defender's Office representing Marnez Smith. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. To begin with a brief recap of the facts in this case, Mr. Smith was convicted of computer crime, theft, multiple acts in this case. And the facts are really that Mr. Smith was a teller at a bank, and the state alleged that he stole $3,200 out of a teller without the customer's knowledge. And that's what led to the convictions. Getting into my issues, I plan to talk today about issue 1 and issue 3 and submit issue 2 on the briefs unless, as I know from yesterday, this court, who knows where we'll go. So that's my plan at the beginning. So starting with issue 1, the alternative means analysis. The statute itself, I think, admittedly is ambiguous and could be read multiple ways. So I'm going to start with the PIC committee's reading of the statute, because I know I usually get the PIC committee thrown at me. And this time I want the PIC committee's interpretation of the statute for this court to follow that interpretation. And so the PIC instruction, which was the instruction given in this case, reads as follows. The defendant used a computer for the purpose of executing a scheme with the intent to defraud, or for the purpose of obtaining money, or with any other thing of value by means of false or fraudulent pretense or representation. So my primary argument is that the first half of the PIC instruction, as is interpreting the statute, has the element of intent to defraud. There is the defendant must have the intent, that mental state. And specifically, the intent to defraud requires another person. It requires their intent, at least, I mean, to have another person act upon their fraud, to get them to give them something. And then the second half of that, after the or, for the purpose of obtaining money or any other thing of value, there is no intentional component to that. And so I would actually argue that that second half has no mental culpability. And I would base that argument on this court's recent precedents of Dinkle, which relied on Pulliam, if I'm saying that correctly, where we go down and we look at the alternative means and we see that some alternative means have mental culpabilities and some don't. And based on my argument that this is an alternative means issue, the second half here, based on this court's reasoning in those cases, there is no mental state. And so that's really the elements that give us the alternative means. Is before the or we have intent to defraud, after the or we just have conduct.
Well, doesn't intent modify both defraud and obtain?
So my first answer is that's not how the PIC committee wrote it, and that's not the PIC committee's interpretation. My second argument was, even if we go that route, which I think that's how the Court of Appeals read it, while my argument I'll allow isn't as strong, because when we now have an intentional component, it's the intent to. It's still different. The intent to defraud requires the person to have the mental culpability to get another person to act and to try to get them to do something. The intent to obtain money by false or fraudulent representation does not require the intent to have another person act to get them to do something. It can, but why would the legislature then have these two? Why would they write it separately? And why would the legislature not just include, why would they just take out the part with intent to defraud and not just include the false and fraudulent representation if they just wanted it to be all encompassing? So I think based on that, we don't read extra language into statutes. Even if we go your route of interpretation, it's still two different mental states. One's the intent to get someone to act and to try to get them to give you some kind of interest. And the other one is just your intent to just take something, to just act like it doesn't require the victim to actually.
What do you
get
think the
interest.
phrase false or fraudulent pretense or representation?
Really any kind of dishonest conduct. So I think I know where you're going. I think you're going to say that that could include the intent to defraud.
It just seems like the legislature is saying the same thing two different ways, potentially.
I agree. I agree that false or fraudulent representation could include the intent to defraud, which the Court of Appeals really hung their hat on. But I don't understand why the legislature would put in this extra language. And based on our rules of interpretation, we should interpret this so we don't have this extra language. So that what the legislature really meant was the intent to defraud, as we know from its definition, requires the intent to get another person to act to give you some kind of interest. And the second half doesn't require the intent to have someone give it to you. It just requires the intent to go get it. So I think I used the example in my
No,
brief.
it says by means of false or fraudulent pretense or representation. And if I just walk down and grab your keys, I may be committing a theft, but it doesn't require false or fraudulent pretense or representation, does it?
No, not under that, it wouldn't.
So what is that in the statute? By means of false or fraudulent pretense or representation?
Well, I would use the example I used in my brief, where if someone hacks into a bank and they're acting as though they sign in and act as though they're the victim, that would be false or fraudulent representation. But it doesn't require some intent to defraud, it doesn't require the victim actually do something, or it doesn't require the defendant to attempt to induce the victim to do something.
And you're saying that's the added element that's included in the word defraud,
Right,
which is different from false or fraudulent pretense.
right, because we have to read them differently, or else we'd be just having this extra language, which would go against our rules of interpretation. And then so either interpretation, which I will again emphasize the PIC committee did not follow that route. There's still no evidence in this case of the intent to defraud. All the evidence that was alleged just showed that Mr. Smith was basically just taking money out of a cash drawer without inducing anyone to give him money. I mean, an example of intent to fraud would be if he lied to the, was printing out things and trying to get them to sign electronically to show that it was a valid transfer. And there's no evidence of that in this case. In fact, the slips had no signatures whatsoever. And so based on that and based on this court's precedence of super sufficiency, we would ask that alternative means is missing, and we would ask for a retrial on just the alternative means that sub evidence supported for that first issue. No other questions on that issue. I'll briefly just talk about issue 3. So issue 3 is my restitution issue. And in this case, we had a trial, and the state admits in their brief that the trial proved that Mr. Smith, the evidence tended to show that Mr. Smith stole $3,200. Then at the sentencing, they asked if there was any objection. For unknown reasons, there was $4,100 was requested. And Mr. Smith's counsel was asked what she wanted to do, and she said she had no objection. And she specifically said on the record she had no objection because that's what the trial proved. But we know that the trial did not prove that. And we also know, I mean, I think we can base on that language that the defense counsel just made a mistake. She meant to only allow that $3,200 was proven, or obviously she wouldn't have talked about what was proven at trial. And so based on the unique facts here, I mean, the defense didn't put on any evidence at trial. We have undisputed evidence that Mr. Smith supposedly stole this $3,200. I would ask that under this court's precedence, we really don't have a factual basis for that. And I hope that just the lack of objection, we can still go back and get a rehearing.
Is that what you're seeking? Are you seeking a rehearing on this? In Daly, we laid out a path where once there's an error, or if there's even a miscalculation, the state doesn't get a kind of a second bite at the apple. What should we do here?
That's my first request in my petition, is that you just send this back with an order to just enter the $3,200 since it's undisputed. There's no debate about that. And that would be under Daly is what I would rely on for that. And then my second ask is if this court isn't willing to do that because of the unique circumstances of this case, we would ask at least then for a rehearing. And I would just point out that the state is just trying to procedurally default me in this case on this issue. And I'm not really sure why. I don't know. I thought maybe we could do something unconventional. Maybe this court could ask the state if there's a reason why they requested the $4,100. And if there isn't, why they wouldn't concede that it should just be $3,200.
Mr. Lotta, can I take you back to issue 1 very quickly? In looking at the statute, subsection A, we're talking about subsection A 2.
Yes.
And you're saying there's alternative means within subsection A2, but subsection A actually has 5 subsections within it. 1, 2, 3, 4, 5. Why wouldn't the legislature have split 2 into 2 different subsections if that's what they had intended?
My honest response would be, I don't know, but I will say they have done it before. This court in State v. Britt looked at the sodomy definition. And if you go read the sodomy definition, it's just a straight definition. And this court read alternative means into the different ways to commit sodomy based on the statutes. So it's done it before. And as this court recognizes with its precedent, it can happen. That's why we talk about having internal additional alternative means. And I would say that would probably be one of the weaker arguments for the state, because what we really look at is, do we have distinct elements? We look at the conduct, the mental culpability. That's what we're really looking at. And my argument, based on any interpretation of this, is the mental culpability, the intent. It's either not there for half of the statute, or if we're reading it to read with intent to obtain money, it's still a completely different intent that does not require a person. I mean, one, we're requiring a person to have the intent, the mental intent to try to get someone to act under deception. And the other one is just the intent to do something without the person. So one, we need this extra person. I see that as a big difference that we really should get past which I admit is a point for the state. I think we should pass that and get past and really see these alternative means through the intent component.
Would you agree that in this trial, there was zero evidence of a third person being induced to act.
Yes.
So if that's true, should we apply a harmlessness analysis to this alternative means? Assuming we agree with you that this statute does present alternative means, should we analyze this through a harmlessness lens?
No, I would ask this court to follow its precedent and analyze it under sufficiency of the evidence.
And that you're correct. That's what the court has done in the past, but you're probably also familiar that at least some members of the court have suggested that a harmlessness analysis would be appropriate where one of the means has zero evidence. So I'm asking you to respond to that.
Right, I understand what you're saying, Your Honor. My response would be that basically I would adopt the reasoning of this court that we just can't know for sure. We're just, this is sufficiency of the evidence. We see juries convict when there's insufficient evidence all the time. And so we really don't know that didn't happen in this case.
I'm sorry to interrupt, but was the jury instructed on the statutory definition of intent to defraud?
Yes, it was. It was provided.
So you think we can't know whether or not some jurors thought that the defendant was guilty of intent to defraud, even though there was zero evidence of a third person? Absolutely.
I see that, and I have cases all the time where I win sufficiency. Well, not a lot, maybe every once in a while where I win sufficiency of the evidence. So yeah, I absolutely think it's certainly possible. And the jury trial right was just argued in the previous case is so valuable. I don't think we should risk it that some didn't.
I have another question on that point. Now, there is some case law to indicate that the alternative means to be used narrowed by argument. So the argument, I think, in issue number 2 is that both parties argued that this was that the means that applied here was the second to obtain money, property, services.
I would say that number one, would say that doesn't go to our sufficiency analysis, because basically what I was saying with Justice Stiegel was that's what we have in every case where there's insufficiency of evidence. The prosecutor's arguing you should find these elements even though there's an evidence missing. So I don't think you could essentially elect an alternative means, or even if they did, it doesn't go to this court's precedence and when we look for reversibility. It's just whether there was evidence or not. We don't look to what the prosecutors say or what the defense counsel says in argument. There is no, unlike multiple acts instructions, you can't narrow it down. You can't elect which alternative means to follow. We just look at the sufficiency. That's this court's test, and I would submit that intent to defraud is completely missing any evidence in this case. There's no other questions from this court. Done.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is our position that KSA 215839A2 sets forth options within a means and not additional alternative means of committing the crime. This court's standard review is whether a case involves alternative means as a matter of statutory construction subject to unlimited review. We would agree with the Court of Appeals determination that this subsection of the statute does not contain alternative means of committing the crime. The legislature typically signals its intent to create an alternative means by separating alternatives into distinct subsections of the same statute. Here, the legislature did that by creating alternative means for committing unlawful acts concerning computers in subsection A1 through A5. To the state, it makes no sense that the legislature would have done that and then within subsection A2 created additional alternative means instead of just setting that out as a sixth option. So our position is this language that's complained about is descriptive of the types of factual circumstances to prove the conduct that's criminalized under A2, which is the use of a computer system, computer network, or any other property for the purpose of devising or executing a scheme or artifice. Merely describing a material element or a factual circumstance that could prove the crime does not create alternative means.
Well, but the defendant is arguing that there are different elements here. That intent to defraud includes an element that's not included in obtaining money by means of false pretense.
I understand that, and
Disagree with that?
we disagree with that.
What do you do then with 21-5111, which is the statutory definition of intent to defraud, which, as I read it, at least, it says it requires an intent to, quote, induce such other person in reliance on such deception to, transfer property, basically. I'm summarizing the rest of that.
So our position is similar to as the Court of Appeals found that deception needed to defraud someone necessarily requires a false or fraudulent pretense or representation by the person committing the fraud, which flows to the other part after the or in the statute, and intent to act under false or fraudulent pretense. Essentially, the intent to defraud or the intent to act under a false or fraudulent pretense is a distinction without a difference.
Are you saying both of those descriptions require a third person to act?
I don't think so. What I'm saying is they both involve dishonest conduct, and that is the specified object here that has been criminalized, because it's the use of a computer, and the specified object of a scheme or artifice is engaging in dishonest conduct.
But again, just the statutory definition of intent to defraud is broader than just dishonest conduct. I mean, it's very specific.
I would agree it's very specific, but I think it goes back to the fact that we know that the legislature, when they are setting out, typically, if they want alternative means, they are going to set them out in separate subsections. And here it simply defies, it just doesn't make sense that they would pack additional alternative means into one subsection.
Do you know how or why the jury was instructed on the statutory definition of intent?
I cannot speak
Don't.
I don't recall. I mean, if there's discussion about that, obviously the record would bear that out. But I don't recall if that was a specific discussion. I do know that the jury instruction that was given here was also included in the defendant's packet. So it was requested by defendant as well. Additionally, to further our argument, the options within an alternative here, it's our position, do not constitute further alternative means themselves, because they do not require proof of an additional and a distinct material element. And as the Court of Appeals found, and we agree, this subsection does not contain further alternative means. So it is our position that the Court of Appeals was correct in their determination on the first issue. Unless there are other questions.
Assume with me that we disagree and that we do find that there are alternative means. Do you agree there's no evidence of both, of one or the other?
And yes, in the briefing, I did admit that as far as a intent to defraud, if we're parsing that out, the evidence here did not show all of these transactions occurred when the account holder was not present. There was no presence by them. There was no signature by them. But as set out in the brief, assuming everything that the defendant claims to be true, we argue that there was abundant evidence of obtaining money by false means of false or fraudulent pretense. And we would ask that this court could reliably determine that the alleged error here was harmless. So we would, understanding what you have found in the past, we would ask for a harmless review in this case under the proposed modified harmlessness approach, and find that there is sufficient evidence of the alleged other alternative means, the intent to act under false or fraudulent pretense. That answer your question?
It does. I guess what I'm struggling with is, as I said here, is what about the bank? I mean, your argument went to the person whose money it was, definitely. But does the bank not have a role here I mean, the bank is holding that money, has some fiduciary responsibility to its account holder. And it seems to me that there's an argument that the bank was, there was an intent to deceive the bank, to induce it to release the money to someone who had no right. What am I missing?
Well, I would admit that in handling this case, for however long I've had this case, I've never actually thought about the bank, because we had these 4 account holders. And possibly because of the definition, the statutory definition of intent to defraud is an intent to deceive another person. But as you've stated, yes, the bank is out the money, and was basically through his actions induced to turn it over. And if you look at the sentencing journal entry, the restitution goes to the bank. So I wouldn't disagree with you. I've just never thought of, honestly, have never thought about the bank.
Do you know if we have any case law that in the arena of intent to defraud that interprets induce such other person to include digital transactions in which it's the robot,
Right.
It's the computer that's doing, but the computer's been programmed by a person. So there's no actual person acting, but as Justice Lukert's suggesting, presumably there was a defendant had an intent to deceive the computer in order to convince the computer to give him money. Is that an accurate layman's description of what happened?
I would say yes. I mean, he went into the computer, into the accounts, and actually.
And he lied to the computer, and the computer gave him money. I mean,
Yeah.
again, is that a really, probably way oversimplified explanation?
No, I mean, I think that's what occurs here. Specifically, I don't remember. I know there's the part where the account holders did not sign for this, but yes, he had to go into the computer to do something to get the cash drawer to open.
So that's just my question. Do we know whether we have any case law that says that the language describing an intent to defraud that refers to such other person is broad enough to capture computer programs or digital transactions effectively?
I do not know, because I did not look at that way, but that is, that's an interesting way to think about it. And I mean, that's what happened here.
Even a person that's wearing 2 hats. I mean, at that point in time, the defendant's wearing the hat of agent of the bank, and is in essence defrauding the agent who is doing the teller that's doing the mechanical That may be a even slimmer distinction since it's one person, but from a legal standpoint, it is two people in essence, both the fiduciary and the
True, because while he took the money from these 4 accounts, I believe because the restitution is going to the bank, the bank then covered that loss, gave it back to the account holders, so then the bank is out. So I can see, again, I didn't think about it that way, but the way you've described it, I could see that as fitting. I would have to look into it more. If there are no other questions on issue 1, I'll briefly issue 2. So it was our position, and the Court of Appeals agreed that any error in the restitution amount here was invited because the defendant acquiesced to the request for restitution in the amount of $4,100, preventing the state from presenting evidence to support that requested amount.
acquiesce. Context, at least, of our jury instruction case law, where we have said that acquiescence isn't enough to invite an error. Why would it be different here?
Here, I thought of that, and I think it is different here because in the realm of jury instructions, you look at whether defense counsel actively pursued or actively did something to make that the court relied on to act, to either give an instruction or not give an instruction, basically inducing the court to do something. Here, the defense counsel's acquiescence essentially induced or caused the state not to put on any evidence to support that number that was different than what was shown.
Does the state have that evidence?
Admittedly, I do know what in my getting into the case, I do know where that number comes from. It is not in the record. If the court wants me to explain, I can, but basically that fact it kind of shows what the court, why we don't have that information. The state didn't present it because the defendant did not object to the amount. And so relying on that, that was the state's request, and they didn't prove it up.
But you're saying as an officer of the court, it wasn't a mistake. That there's a real claim there for the difference between.
I didn't read it as a mistake, and I think it's because I know and discovered some of the things going on prior to getting to trial and the charging of the case. So that's why I don't read it as a mistake. Is it possible that was a mistake? Maybe, but defense counsel here was counsel through the entirety of the case, I believe. And so I don't think it was a mistake.
I mean, that's the problem. And one thing, if you say he acquiesced, so we didn't come forward with evidence that we have that would have shown the number. And I understand that. What I don't understand is putting a back door on it and saying, well, there might have been a mistake out there somewhere. Because if it's a mistake, then it's harder for me to believe that the state is harmed by acquiescence. So I think you have to stand right there and tell this court that was a real number and that you didn't get to put on evidence because he acquiesced to it.
I understand that. And if the Chief Justice wants me to explain, again, it's not in the record.
I don't need you to explain anything. I need you to tell me that that's the case.
It's
that
a real
you as an
number.
officer of the court believe that that's the case based on what you've seen.
Yes.
That's all I'm getting at.
It's a real number. So we believe because defense counsel did not object and told the court it did not object to that number, that there was an acquiescence. Now, if this court does not agree with the Court of Appeals determination or my argument, we would ask, as opposing counsel said, there are two options. Either you vacate the order and put in the $3,200, which was proved at trial, or send it back and allow us to put the evidence on the record, since we weren't, didn't have the opportunity at sentencing the first time. And I fully understand that this court has cases where they've said, if we don't prove it up the first time, we don't get another shot. But I believe those are situations where we've had an evidentiary hearing and we just missed the mark in proving the amount. Here, we did not have that opportunity. And if there are no other questions, I would simply ask this court to affirm the decision of the Court of Appeals. Thank you.
May it please the court. I would like to respond to Chief Justice's question about the bank's interest. And in the intent to defraud definition about whether the bank had an interest and Mr. Smith intended to defraud the bank as well. And so there's some evidence of that. In the intent to defraud definition, it uses the word person. And then in that same statute, there's the definition of person. And a person means an individual, public or private corporation, government, partisanship, or unincorporated association. So while maybe the bank's a corporation, which I don't think they put on any evidence of, the computer system certainly isn't any of those things. And certainly property owned by any of those would not.
Well, if you
amount
just
to a person.
substitute the word bank for person in the statute, why doesn't it fit?
Because he didn't have any intent to defraud the bank. He wasn't trying to get the bank to do something.
Well, it says an intention to deceive, I'll just say the bank, and to induce the bank in reliance on the deception to transfer property. Isn't that exactly what happened?
But the bank didn't, I don't understand how you intend to defraud the bank. He just took the money from the
Well,
bank
that-
by
okay,
false or
so
fraudulent pretenses.
What does that mean that he just took the money?
That to me would be under the second half where it's by false or
No,
fraudulent.
I just
pretenses.
mean factually educate me. What was the actual evidence? Like how precisely did this crime occur? Was it like was it cash? Was there an open
Yeah, he was
drawer?
basically
He just
doing a
walked-
withdrawal without the presence of the,
Okay, so he had to type something into a computer.
yes.
So why isn't that a lie to the bank that induces the bank to then give him money?
My response is that you cannot induce an inanimate object to do something.
What if, but
Without the person that.
well, the
is-
definition of a person includes the corporate entity.
I understand. And so this is how I would distinguish that is the corporate entity as the bank. And then we divvy that down to their personal property and going in and typing into a computer owned by someone. Without their, I mean, he could do this without the bank. He could do this with any computer. He could have come in from somewhere else. He could have come in from outside and hacked in. I mean, you don't need the bank. And I just don't think you can intend to defraud a non-living thing. There's no way to get the bank can't be induced to, there's no intention. And he certainly didn't have the intention to get the bank to believe these things and to then give him the money.
Oh, he
Wasn't
did
that-
all that to cover up the crime so that the bank wouldn't catch him. So that's, I mean, that seems to be a fairly easy supposition to make here. Why else do it? Otherwise, why attribute the withdrawal to a customer? Why not just take money from the drawer? Because he had to have the bank think that the customer took that money out, and the customer is a fiduciary of the bank.
I understand. I would stand by my position that you can't intend to defraud them. And then I'd also argue that the state never raised that argument in its briefs. That would be my position on that.
What about the acquiescence? I mean, essentially, the state's saying that the defendant did a bait and switch here, that you didn't object to the number that went into the journal entry, but now you're saying, oh, wait a minute, we didn't, this is an error and we didn't invite it. So it seems to me that based on this, the easier way to go is just to send that issue back down to the trial court and let everybody figure out what the right amount is.
And I would also be okay with that. And I would just point out that there's evidence in the record that it wasn't a bait and switch because the trial attorney in this case said that's what was proved at trial. And that wasn't what was proved at trial, 4,100. And so it wasn't, I would argue it wasn't a bait and switch. Unless there's any other questions, I will rest on my briefs. Thank you, Your Honors.
Thank you to both counsel for your arguments. We will take this case under advisement. The court will now be in recess for 15 minutes.